Good morning and welcome to the presentation on the St. Louis Public Schools Board of Education Policies and Regulations. My name is Leslie Tolliver and I'm the coordinator of the Employee Relations Department. The St. Louis Public Schools are committed to providing a safe, unbiased working environment, and the policies and regulations we will discuss today guarantee the rights of each employee. Starting with Policy 2471, St. Louis City Public School District does not discriminate on the basis of sex, race, religion, color, national origin, ancestry, age, disability, sexual orientation, gender identity, veteran or National Guard status, or any other factor prohibited by law in admission or access to or treatment or employment programs and or such activities. The district employees, as is stated here in Policy 3541.4.1, are not allowed to transport students in their personal vehicles. So no district employee may transport children in a privately owned vehicle to or from school or to or from a school-related activity unless as a parent or guardian of that particular child. Additionally, district employees who use their personal vehicle for approved district purposes shall be reimbursed. The whistleblower policy is covered under Policy 4110. It encourages persons to disclose serious breaches of conduct covered by SLPS policies, procedures, and/or laws. It protects our employees from reprisal by adverse employment actions as a result of having disclosed wrongful conduct, and it provides individuals who believe they have been subject to reprisal a fair process to seek relief from retaliatory acts. Board Policy 4123 complies with the ADA Act with respect to disability. A disability can be defined as any physical or mental impairment which substantially limits one or more of an individual's major life activities. Major life activities include, but are not limited to, walking, seeing, hearing, speaking, breathing, performing manual tasks, learning, working, caring for oneself, sitting, standing, lifting, or reaching. An employee is considered disabled if he or she suffers from a disability, has record of said disability, and is regarded as having a disability. The board will, upon request by an otherwise qualified individual with a disability, will make a reasonable effort to determine if an appropriate, reasonable accommodation can be made and implemented, and if it does not impose undue hardship to the district. If an employee becomes disabled during his or her employment with the board, upon request by the employee, the district will make reasonable accommodations that do not pose an undue hardship. The board may require the disabled employee to undergo a physical examination at the board's expense to assist in making reasonable accommodations under the law. Requesting accommodations. An employee who suffers from a disability and is unable to perform the essential functions of his or her job without reasonable accommodations shall make a request for a reasonable accommodation with their principal or immediate supervisor. The principal or immediate supervisor shall attempt to accommodate the employee. If no accommodation can be reached within 10 working days, then the request should be forwarded to Employee Relations for investigation and make a recommendation to the Human Resource Officer within 15 working days. The Human Resource Officer shall consider the recommendation, make an alternative decision, or deny the request within 20 working days and may seek a legal opinion from counsel. Appeal may be made to the ADA Committee within 10 days of being rendered. The committee will decide whether to sustain or deny a Human Resource Officer's decision within 60 working days of the appeal. The employee may make a final appeal to the superintendent of an adverse decision within 10 days of the decision that was made by the ADA committee. The superintendent from that point shall affirm or deny the appeal within 20 days of the appeal. The Board of Education, under Policy 4124, prohibits discrimination in employment and activities based on an individual's sexual orientation. With respect to Board Policy 4223, criminal background and felony convictions, the district shall conduct a criminal background on all employees before beginning any job duties on behalf of the district. A current employee who is arrested, charged, convicted, or pleads guilty of any criminal offense must report that occurrence to the Human Resource Division within 3 working days. Failure to report any criminal arrest, charge, conviction, and/or guilty plea, regardless of suspension or execution of sentence, shall be grounds for immediate disciplinary action, including termination. Attendance. Board Policy 4610.1 speaks to teacher attendance. Teachers' school hours begin 10 minutes prior to the opening of school and end 10 minutes after school dismissal. Tardies are such that they are disciplinary in progressive disciplinary in action, and after a fourth tardy within a calendar year, disciplinary action may begin, beginning with the verbal counseling, leading up to and including termination proceedings. If you're going to be absent as a teacher, you must notify your building principal 1 hour prior to your scheduled report time. Substitutes must notify the substitute office no later than 5:45 a.m. to report an absence. Teachers are expected to use personal time off, otherwise known as PTO, in accordance to Board Policy 4620.1, which will not count adversely on the performance evaluation of the teacher. Unexcused absences. If a teacher fails to follow Board Policy 4620.1, he or she will be charged with an unexcused absence and pay will be deducted. Medical documentation is required for unexcused absences prior to return to work. When records indicate continuous abuse, appropriate disciplinary action will be taken up to and including termination. In the event a teacher accumulates unexcused absences within the same school year, the following disciplinary action shall be implemented. After the first unexcused absence, verbal counseling. The second, a second verbal reprimand. Third, a written reprimand. A fourth unexcused absence in the same school year, a final written warning and disciplinary suspension. The fifth unexcused absence within the same school year includes termination proceedings to be initiated by the Board of Education. Non-certified staff are governed under Regulation 4610.2. Their workday suggests that all certified and non-instructional employees are expected to report to work on time unless prevented by illness or injury. All employees are expected to clock in and out every day. Tardiness for non-certified and non-instructional employees would be if an employee reports to work more than 2 minutes after their designated start time. The employee is deemed late. 2 incidents of lateness shall equal 1 tardy. If an employee accumulates excessive tardies within a calendar year, the following disciplinary actions shall be implemented for either 10, 10.5, or 11-month employees. After the fourth tardy occurrence, verbal counseling is the point of discipline. The fifth, a written reprimand. The sixth tardy, a second written reprimand. The seventh tardy is a final written reprimand and disciplinary suspension. The eighth tardy could conclude in termination from the district, which would be initiated by the Board of Education. 12-month employees, same line of disciplinary, from 4th to 9th tardy, including progressively verbal counseling, second verbal reprimand, a written reprimand, second written reprimand, a final written warning and disciplinary suspension, and then termination proceedings. All employees are expected to use personal time off in accordance to Board Policy 4620.1, which will not count adversely on the performance evaluation of that employee. Again, if you fail to adhere to Board Policy 4620.1, you could be charged with an unexcused absence and pay be docked. Paraprofessionals, under Board Policy and Regulation 4610.3, shall report to duty 10 minutes prior to the beginning of the instructional day. Again, all paraprofessionals are required to clock in and out every day using the Chronos database equipment. Employees who report to work 5 minutes as a paraprofessional or later after their designated start time, but before the start of school, shall be deemed tardy. School-based paraprofessionals who experience tardies are disciplined in a progressive manner, much like other employees for the district. starting with a fourth tardy in a calendar year and ending with an eighth tardy in a calendar year. The progressive discipline include verbal counseling, written reprimand, second written reprimand, final written warning and disciplinary suspension, and finally, termination procedure. An employee who fails to report at designated starts by designated start of the day but arrives before lunch is deemed to be absent for one half of the workday. If he or she arrives after lunch, it's absence a full workday. Notify your building principal at least 1 hour prior to your scheduled report time. And again, all substitutes must notify the substitute office no later than 5:45 a.m. to report an absence. Failure to make contact will result in an unexcused absence. Any employee who fails to report to work and also fails to personally notify his or her immediate supervisor and or the substitute office will be given a verbal warning in addition to giving an unexcused absence. Any employee who fails to report to work and or notify their supervisor in 3 consecutive days shall be deemed as an abandonment of position. The employee will be notified via registered mail of failure to report to work, and as well as provide a notification of absence to the immediate supervisor. If no response upon receiving this certified mail within 3 calendar days, the employee shall be terminated. Regulation 4620.2 discusses the FMLA, or Family and Medical Leave Act. Eligibility means that an employee has to have worked for the district for 12 months, and within those 12 months have worked at least 1,250 hours. A serious health condition could be the reason for the request of an FMLA leave. Any illness, injury, impairment, or physical or mental condition that involves a patient care in a hospital, hospice, or residential facility. Any period of incapacity requiring absence from work of more than 3 consecutive calendar days. That also involves continuing treatment by a licensed healthcare provider and at least 2 in-person visits or 1 in-person visit plus a regimen of continued treatment. Or treatment by a licensed healthcare professional for incapacity due to pregnancy or incapacity, chronic or long-term health condition that is incurable or so serious that if not treated would result in incapacity for an extended period of time. An eligible employee is entitled to a maximum of 12 weeks of unpaid leave in a 12-month period for FMLA. Military care providers are entitled to 26 weeks to care for a recovering member of the armed forces. Leaves of absences include a birth of a child, adoption or foster care of a child, the care of an employee's child, spouse, parent who has a serious health condition, employee's own serious health condition, existing arising out of active duty or call to active duty status of spouse, son, daughter, or parent in the National Guard or Reserves, or the care of an employee's spouse, son, daughter, parent, or next of kin who is a member of the armed forces who suffers from illness or injury while on active. Intermittent FMLA leave, an employee becomes eligible to take that within a period of 12 consecutive weeks, may use the leave intermittently or under certain circumstances, and that is available in order to reduce the work week. An employee taking FMLA due to one's own serious health condition may opt to use accrued PTO, vacation, or any other previously accrued paid time off available to run concurrently. Written notice must be made 30 days in advance of the leave whenever possible. Accrual of sick time. Full-time employees are eligible to earn sick leave July 1st through June 30th. Certified teachers, administrators, and non-certified staff receive 10 days. All 11-month employees receive 11 days of sick time, and all 12-month employees receive 12 days of sick time. Sick leave is prorated for employees hired after the beginning of the fiscal year. When an employee uses sick leave for an absence when they are not actually sick, it's covered under Regulation 4622. Falsification of medical documentation, failure to provide documentation for absence, or absence for work on an inordinate number of Mondays or Fridays without sufficient documentation is considered abuse. Regulation 4830.1, reporting acts of violence. The school administrators shall report acts of violence to teachers and other employees as provided in regulations 5150.1 and 5150.2. When any person has committed an act which, if committed by an adult, will be assault first, second or third degree sexual assault, or deviant sexual assault against a student or school employee. When a student is discovered to have in their possession a controlled substance or a weapon in their possession on school property. All school members and staff members are required to perform their job duties in a professional manner that serves as a positive role model for students. According to Board Policy 4840, the sole function of the district is to provide a quality education for the students of St. Louis Public Schools. Staff members are required to comply with all federal, state, and local laws that relate to the performance of job duties and the policies and regulations of the district. Failure to comply with all federal, state, and local laws relating to an employee's job performance or failure to comply with the policies and regulations of the district will result in disciplinary action, including termination. Board Policy 4841 prohibits the use of tobacco on St. Louis Board premises. The use, distribution, or sale of tobacco, including any smoking device, or carrying of any lit smoking instrument on SLPS owned, leased, or occupied facilities, or at events on SLPS properties, or in SLPS owned, rented, or leased vehicles is prohibited. This includes all campuses, all parking facilities, and lots. SLPS buildings located near city municipality owned sidewalks within 20 feet of entryways or exits, near air intakes, or near fire explosion hazards. If an individual within SLPS smokes or uses tobacco products off properties, they are expected to be respectful of businesses neighboring SLPS campuses and properties. They should not loiter in front of homes, businesses, or facilities near SLPS campuses or properties, and must discard tobacco products in appropriate receptacles. The free distribution of tobacco products on SLPS property is prohibited. No tobacco-related advertising or sponsorship shall be permitted on SLPS property, SLPS-sponsored events, or in publications produced by the SLPS. Violations of this policy may result in disciplinary action. Sexual harassment is covered under Board Policy 4843 and is defined under Title VII as sexual harassment, including unwelcome sexual advances, requests for sexual favors, and verbal or physical conduct of sexual nature when submission to such conduct is made either explicitly or implicitly a term of condition of an individual's employment, or submission or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual. Or such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Or if qualified employees are denied employment opportunities or benefits because the opportunities or benefits are given to another employee who submitted to an employer's sexual advances or request for sexual favors. In the educational context, Title IX prohibits discrimination based on sex, including sexual harassment, in any educational program or activity that receives federal funds. The U.S. Department of Education Office of Civil Rights defines sexual harassment as verbal or physical conduct of sexual nature, imposed on the basis of sex by an employee or agent of a recipient that denies, limits, provides different, or conditions the provision of aid, benefits, services, or treatment protected under Title IX. Submission to such conduct is made either explicitly or implicitly a term of condition of an individual's academic status or progress or employment. Submission or rejection of such conduct by an individual is used as the basis for educational employment decisions affecting such individual, creating an intimidating, hostile, or offensive educational or work environment, or the denial of educational or employment opportunities or benefits because they were given to another student or employee who submitted to sexual advances or requests. Sexual harassment of students by school employees is prohibited, regardless of whether the employee's conduct is welcome or otherwise invited. For all full-time, part-time, substitutes, and other employees, including all volunteers and any non-employees who visit school premises and or school activities, including off-campus school-sponsored events. Unwelcome sexual advances are determined on a case-by-case basis and may include, but are not limited to, the following: An invitation or propositioning intended to result in sexual liaison, regardless of how subtle the invitation, or invitations to social non-work related activities if refusal to participate results in the loss of employment opportunities or adverse employment are verbal conduct, which includes but not limited to sexually provocative or explicit speech, publicly expressed sexual fantasies, jokes of a sexual or crude nature, derogatory comments regarding either gender as a class or demeaning comments, threats of consequences for failing to submit to sexual advances, or sexually explicit writings or other sexual depictions. Physical conduct of a sexual nature could include, but is not limited to, unwarranted or unwelcome touching, kissing, etc., sexually offensive pranks, or sexually explicit cartoons, graffiti, or other sexual depictions, or sexually suggestive. Subjecting students in a predominantly single-gender classroom setting to sexual or sex-based remarks, comments by peers and employees can be considered sexual harassment. Interfering with the student's educational opportunity in a predominantly or historically single-gender academic environment by preventing the student from accessing tools, equipment, basing performance evaluation on gender, hiding equipment, or suggesting the student does not belong in the academic setting due to his or her gender. Limiting or denying access to education opportunities based on gender is considered sexual harassment. Sexual harassment is not limited to conduct by males towards females and can occur between any of the following: student on student, staff on student, staff on staff, male on male, student on staff, female on male, male on female, as well as female on female. Investigation of sexual harassment complaints. The policies are strictly enforced. There are disciplinary actions and consequences if found to have violated Policy 4843 with respect to sexual harassment. Policy 4844, drug-free workplace. Any employee found in possession of drugs prohibited by this policy or suspected of being intoxicated or under the influence of drugs or alcohol shall be subject to disciplinary action, including dismissal. Any employee who, as a result of testing, is found to have identifiable traces of a prohibited drug or alcohol in his system, regardless of when or where the drug or substance entered the employee's system, will be considered in violation of this policy. The employee will be removed from the board premises and will be subject to disciplinary action up to and including dismissal or termination. When a supervisor has a reasonable suspicion based on objective criteria that an employee is under the influence of alcohol or drugs while on the job, he or she shall immediately report this by telephone to the Human Resource Office and/or his or her designee. A written report must be submitted by the supervisor within 48 hours. Upon receiving a report as described in Section 1, the Human Resource Officer or his or her designee shall direct an employee to go immediately to a medical facility to provide urine and/or blood specimens for testing and to receive a medical examination by a licensed physician to determine his or her fitness to work, job performance, and as well as to report workplace convictions. Board Policy 4847, Computer and Acceptable Use. District software is licensed for use only by the district and will usually contain license restrictions regarding the use or copying of the software. The use, copying, or loading of a non-district licensed or personal software by students or staff is strictly prohibited unless approved in writing by the District Director of Technology. Policy 4847 prohibits the following uses with our computer systems: personal and commercial business, political, illegal or indecent, persons other than staff or students, to access or distribute confidential information, and disruptive use. Please remember that the use of an SLPS issued computer is a privilege and not a right. Access to and use of district computer resources should be taken very seriously. All users of district computer resources are responsible for the proper care and operation of district computer resources. Policy 4848 speaks to the district's social media policy. The district prohibits use of accessing personal social media, allowing students to access personal social media, friending current or former students, Improperly discussing current or former students, or discussing or posting confidential or proprietary information about the district's employees, students, or agents on social media. Making unprofessional comments that negatively portrays St. Louis Public Schools, its staff, current or former students, including profanity, threats, and bullying, or encouraging others to participate in this type of action is prohibited. Allowing current or former students to access, operate personal electronic devices, including but not limited to cell phones or personal computing devices, is prohibited. Using, accessing, or operating a student's personal electronic device is also limited while in St. Louis Public Schools property. St. Louis Public School prohibits all forms of hazing, bullying, and student intimidation. This is covered under Board Policy 5131.9. Students participating in or encouraging inappropriate conduct will be disciplined. Hazing is defined by any activity on or off school grounds that a reasonable person believes would negatively impact the mental or physical health or safety of a student or put the student in a ridiculous, humiliating, stressful, or disconcerting position for the purposes of initiation, affiliation, admission, membership or maintenance of membership in any group, class, organization, club, or athletic team, including but not limited to a grade level, student organization, or school-sponsored activity. Bullying is defined as intimidation or harassment of a student or multiple students perpetuated by individuals or groups. Bullying includes but is not limited to physical actions, including violence, gestures, theft, or damaging property, oral or written taunts, including name-calling, put-downs, extortion, or threats of retaliation for reporting such acts. Bullying may also include cyberbullying or cyber threats. Sending or posting a harmful or cruel text or images using the internet or any other digital communication device is considered cyberbullying. Cyber threats are online materials that threaten or raise concerns about violence against others, suicide, or self-harm. Board Policy 5144.1 is our school violence and restrictive behavior. The purpose of this policy is to promote safety and prevent harm to students, school personnel, and visitors to the school district, to foster a climate of dignity and respect in the use of discipline and behavior management techniques, to provide school personnel with clear guidelines about the use of seclusion, isolation, and restraint in response to emergency situations, and promote the use of non-aversive behavioral interventions. Corporal punishment is prohibited at St. Louis Public School District. Physical restraint, preventing a student from hurting himself or herself, is allowable in order to protect others. Physical restraint is allowable in order to protect the staff's well-being. Physical restraint is allowable. Isolation, meaning the confinement of a student in an enclosed space without locking hardware, is prohibited. Mechanical restraint is prohibited. Temporary touching and holding the hand, wrist, arm, shoulder, or back for the purpose of inducing a student who is acting out or eloping to walk to a safe location is a physical escort. Seclusion is defined as the confinement of a student alone in an enclosed space from which the student is physically prevented from leaving by locking hardware. Timeout is to separate a student from the attention of staff or other students. Chemical restraint is prohibited. If a staff member uses isolation or physical restraint on a student, the following must be done. Report the incident to the building administrator immediately. Prepare a written, comprehensive report detailing the reason for physical restraint, the type and manner of physical restraint, and the amount of force used in said restraint. The comprehensive report must be prepared within 24 hours of the incident. The comprehensive report shall be forwarded to building administration, the office of the superintendent, and the director of school safety and security. Building administration shall also follow all regular district reporting procedures for external agencies as required by district policies. The district administrator shall conduct a debriefing for any incident that results in an injury. Training is provided annually by the district. This concludes our presentation. Thank you for listening. If you have any questions or concerns regarding anything you've heard here or anything that you see during your employment with St. Louis Public Schools, I'd like to encourage you to reach out to the Employee Relations Department. We can be reached at erstaff@slps.org. Thank you very much.